Erode Arts and Science College, Erode Autonomous, A. Helen Sandhya, Assistant Professor, Department of Corporate Secretaryship. Now we are going to see about company law and secretarial practice. First, what is a company? Company is involvement in an association of persons formed for the purpose of doing business having a distinct name and limited liability. They can be incorporated under the Companies Act. Corporations enact under the special enactments. Corporate sole any other body corporate notified by the central government. Features. Features of company. A company is considered as a separate legal entity from its members, which can conduct business with all the powers to contract. Independent corporate entity. It is an independent of its members and shareholders. And next, other features of limited liability either by the share or guarantee. It can own property separate from its members. The property is vested with the company as it is a body corporate. The income of the members are different from the income of the company. Income received by the members as a dividend cannot be same as that of a company. And then next, types of company. Limited company, unlimited company, company foreign private company, company public company. Next, exemption and privileges of private company. It can have a minimum of 2 members. It can commence business immediately. After obtaining certificate of incorporation, it need not issue a prospectus or statement of lay of prospectus. It can leave a minimum of 2 directors. It need not hold statutory meeting or file statutory report with the ROC. Next, public company, which is not a private company, which has a minimum paid up capital for rupees 5 lakhs or such higher paid up capital as may be prescribed, which is a private company and it is not a subsidiary of the company, which is private company. It includes any company which is in public company with the paid up capital less than 5 lakh. Then it has to enhance it paid up as per the statutory requirements. And then registration and incorporation, association of person or partnership or more than 20 members, 10 in case of banking, can register to form a company under the Companies Act 1956. Next, incorporation of company. The person who conceived an idea of company, desired and do the necessary work for the formation of the company are called the promoters of company. The promoters are the persons who desired on the formation of the company. And then next, director, the legal status of the director. The director occupies this position of an as a trustee in relation to the company, as an agent when they act as in behalf of the company, as a managing partner as they are entrusted with the responsibilities of the company, qualifications are. Next, appointment of auditor. The appointment can be sometimes based on the proportional representation like minority shareholders. There can be an alternate directors, additional directors, casual directors. The third parties can appoint the directors other than the shareholders and the first directors. The central government and NCLT may also appoint the directors. And then next, company meeting. A meeting can be convened by the director, requestionist, or the NCLTN. Notice to be given by the secretary after the time and place have been fixed by the director. Even the shareholders can call a meeting as an extraordinary general meeting AGM. The NCLT can call an annual general meeting AGM. Next, winding up. It is a process whereby the life of the company is ended and its property is administered for the benefit of its creditors and members. During this process of liquidators is appointed to take control of the company. The liquidator will be responsible for the assets, debts, and financial distributions for the surplus to the members. It is the process of discharge of liabilities and returning the surplus to those who are entitled for it. But even a company which is making a profit can be wound up is the special feature of winding up, which is different from that of the process of company.